Thank you for joining the R.O.Hammer Company's podcast. In this episode, I was joined by my close friend and commercial litigator, Patrick Newman. Patrick is a shareholder at Bassford Remele in Minneapolis, and Patrick and his team have been helping CSI with their compliance and litigation needs for about a decade now. Aside from being a great attorney, Patrick is also a pretty amazing human being. I hope you enjoy the episode. Patrick, thank you for joining the R.O.Hammer Company's podcast. How are you today?
I'm doing great. Thank you very much for having me.
It's a pleasure. Are you joining from the infamous 10th Street Towers?
5th Street. We're only half as good as that.
I think I mentioned this recently. Have Jeff Peterson from CPEC 1031 on the show, and he is also downtown and has a pretty amazing view. He is 222 South 9th Street in downtown Minneapolis. Okay. How are things downtown Minneapolis these days?
Busier. A lot busier. There's more people. They've unleashed construction in every quadrant. So it's just, I think there are more people, and it feels like there are a lot more people.
Okay. Well, that's not necessarily a bad thing.
No, it's kind of nice.
Are you working from the home base downtown these days, or are you doing much from home anymore?
I split. It's probably 3 in, 2 out most weeks. I've got a little bit longer commute in these days, so I try to be at the home base a couple of the days. But I do like being here, seeing people. With the firm has grown a fair bit, and just letting people know who you are rather than just like a space on the webpage or whatever is.
I've been to the Bassford Remele headquarters, and it's a nice space. You have a great team. It is a challenge getting in and out of downtown, just like any other metropolitan area. But it's good to hear that it's becoming more vibrant, because it was a ghost town.
I'll tell you what, we just opened an office in Sioux Falls, South Dakota.
Okay.
And from now on, I will send you to Sioux Falls, where I am informed the parking is much easier and more affordable.
Can I land my helicopter in that parking lot?
No one's told me that you can't.
We're good to go then. I appreciate you taking the time. It's always great catching up with you. For those watching who are not familiar with Patrick Newman, can you tell us a little bit about yourself, where you're from, those types of things?
Yeah, so I am an attorney. I live and work in the Twin Cities. Our mothership, so to speak, is here in Minneapolis. Our law firm, Bassford Remele, is somewhere around 60-ish lawyers, I think, by now. And we're in a few different locations, brick and mortar offices here and in South Dakota. I have been in consumer finance for most of my adult life. I guess parlayed that into a legal career doing litigation and compliance work, and now even some corporate and transactional work in those spaces. But yeah, I'm a Wisconsin transplant, so you know where my football allegiances lie. Professionally, that's me. Yeah, I've got a wife and 2 boys, and between family and this law practice, that's enough to keep a guy busy.
As far as practicing law, you've spent the majority of your time practicing in the Minneapolis-St. Paul area, correct?
Yes.
I always like to ask, obviously I interact and interview on this podcast professionals from all over the country. I have worked with your firm and probably a dozen other firms for various business and personal needs over the past decade, but I'm always curious to hear from somebody who's actually practicing. Tell us a little bit about the legal community in the Minneapolis-St. Paul area and how that's kind of shaped your career path.
Maybe this answers your question. My wife and I came here from Wisconsin immediately after undergrad. She was going to go to grad school to become an occupational therapist. I was going to go to law school, and so we were looking for places where we could both get into school, and we landed on Twin Cities. And for part of that time, the plan was to go home, was to go back. And that shifted in part because of the connections and professional roots that we put down. And so getting to know people in the Twin Cities bar in particular was really critical. And any young professional trying to find a professional services gig is well served to get out and talk to those who are doing it if they would like to become part of that community. And so that was really how I did it. That's how I got a job initially while I was in law school as a clerk and then after. So yeah, that was a big part. And the Twin Cities bar is pretty collegial as far as we practice nationally. And so we interact with a lot of lawyers from a lot of different areas, and the legal culture is not the same in some East Coast or West Coast or Southern jurisdiction as it is here. I feel, well, quite at home here. And so it's pretty good. There's a lot of competent attorneys in Minneapolis and all over the state. They don't just have to live here, but this is where most of the action is, especially when it comes to like litigation, for example.
So I want to hear about your path to kind of the type of law that you've focused on for the past decade, but tell us a little bit about your educational journey first.
I took the Tommy Boy path, meaning 5 years to get through undergrad. And that might be generous, actually, in the county. So I did not have myself in a serious place when I began undergrad, and it took me a while. But I would say about what should have been a standard person's junior year, I figured out I wanted to go into the law, and I really sort of caught fire. That motivated me a lot. And so focused myself and my thinking and got through undergrad as quick as I could so I could get to law school. In fact, I needed a summer class in 2010 to graduate from undergrad, which I took, completed in July, got my degree August 10th, I think, and then started at William Mitchell College of Law on August 17th. So moved in a week. It went fast. And so from there, law school was a pretty good fit. Reading and writing are like the two skills that you need the most of in law school, which is not fair, by the way, because a lot of practice of law is not that. I mean, it really helps to be good at that, but there are a lot of lawyers who have other skills and who do quite well, who didn't do well in law school. So that's another podcast about whether
there's lots of areas of practice too. It's tough to peg.
No, that's true.
You're providing counsel on such a wide range of, but retention, knowledge retention.
I think that's a good way to distill it. Yeah, that's very true. And I had some experience in financial services, and I had sort of said, I'm going to broaden my horizons and I'm going to do something else. Who knows? Employment, IP, who knows? And it just never got there. And I'm glad now, in hindsight, that I didn't, because it would have been a shame to have let a lot of accrued knowledge sort of go for no particular reason. And yeah, so my first gig was actually working for a Chapter 7 panel trustee in bankruptcy. And that was eye-opening. You're in federal court, and you're talking about a lot of financial issues, usually in a negative circumstance. And he'd had me suing out what are called preferences and fraudulent transfers and helping him figure out where those claims existed, which was fun. A little bit of detective work and getting let loose to do some actual legal work. I was like reaffirmed. I was like, okay, I'm on the right track here. I think I have the skill set. And I ended up working for a larger firm later in law school, doing creditors' rights work. And yeah, that's just all sort of snowballed, has a negative connotation to it. So I wish I had a better analogy. Lawyers are supposed to be good at it now. but it snowballed into national defense and compliance work for a whole variety of financial institutions, essentially everybody except the brick and mortar banks. And yeah, it was an accident to start with some 20 years ago when I was a young kid. And it's turned out to be the right thing. And, that's how you and I got to know each other. And I've met so many really smart business owners, entrepreneurs, and good thinkers along the way. I was actually telling my older boy, he's really getting into reading, and he's got a lot of really good questions. And I told him that is the real privilege that comes along with learning and becoming well read is you get the opportunity to surround yourself with people who are well read and smart, and to engage with them. You're sort of on a level, and it's a great thing, because I think he's going to be motivated by that. It's going to
How
kind of,
did he respond?
he nodded, which is the reaction to a lot of dads, lofty, not lectures, but just observations. But anyway, yeah, it has worked out, and the people have been good. So, yeah, different type of journey. I don't come from lawyers or anything like that. I'm sort of the first of any even extended family whom I know very well that's a lawyer. So I'm carving a new path, so to speak.
I think it's coming up on 15 years or something close to that since we've been working together. And um, you have some great people around you as well, which I want to talk about. Let's actually dive in a bit here and talk about. So, what would you say your consumer finance, litigation, defense, is that your primary practice? Or how would you describe
Yeah,
it? What is the
I
appropriate
suppose.
nomenclature these days?
Well, I am responsible for the consumer finance moniker, but I'm still not convinced that's a meaningful phrase. It
That's why I'm asking.
well, it invites the question, I guess. Yes, we defend lawsuits under all sorts of federal statutes and regulations, state statutes and regulations that all involve um, consumer protection of various types. It's almost always with respect to financial services, but not always. And um, yeah, I would call that the core of what we do. Um, Maybe like a third, 66% litigation. And then maybe a quarter beyond that is compliance. Those folks in those industries, they're so heavily regulated that either just having someone to soundboard off of from a compliance standpoint, or to do in-depth compliance analyses about, hey, we're going to do this thing, how should we do it? Or, hey, we found this thing, what should we do about it? That's probably a solid quarter and growing. Um, and then we've introduced, like I said, like actually papering deals and contracts and what have you for existing clients and others. And so I don't know what's the difference between 25 and 33, 8% ish, and also trying to grow that as well.
As you know, I operate in a highly regulated industry, accounts receivable management, and Bassford has done quite a bit of compliance work on the front end, policy, procedure, vendor due diligence. Could probably go on and on, and it's an important piece of the puzzle in some of the industries that your clients participate in. Um, let's talk just a little bit high level about kind of the state of consumer finance litigation and compliance in financial services industries these days. We're kind of entering post-election, what some would call a deregulatory environment that doesn't seem to slow down litigation that much. Give us your sense or perspective of the current landscape.
Yeah, our group started some 30 years ago, well before I was an attorney, and we primarily served those in the accounts receivable management space. That was essentially everybody we represented. We were very focused. We've grown that out substantially. We still love our friends in that space. Um, they are being targeted in different ways today than they were even 5 or 6 years ago. And I would say the biggest hurdles for the broadest groups are those folks who are involved in credit reporting for the decisions whether to lend, as well as Telephone Consumer Protection Act. So if you're making outbound communications, those remain the two big ones that are most broadly applicable. We're seeing those are the newest cases we're seeing with the greatest regularity. And we get a pretty good sample size because we're doing these around the country. And so it's not like I'm just reporting in from Minnesota. I'm telling you that's also true in the Southern District of Florida and in California and all the rest. I can also tell you that the regulators at the state level have been pretty active. We don't have to go in today about what it means for like the Consumer Financial Protection Bureau. Is it a thing? Does it have any teeth left? What do those regulations mean? We're going to learn that over time. But I can tell you that pretend for a moment that was all deleted and it's just gone now. Mm-hmm. There's 50 others and they all have different ideas about what compliance means. So in some ways, I can appreciate why business owners would say, just give me a break from, the big, strong arm federal regulator. But it's also, at least there's some layer of predictability to that, that you might have with 50 others. But so we're interfacing a lot with the state regulators, investigations, enforcement actions. So progress is not linear, is the thing I myself saying. So
let's talk a little bit about the CFPB. This is something that comes up on this podcast quite frequently. And I don't disagree with your statements. It's kind of the devil in a sense. I think I would be hesitant to say that there are going to be 50 state-level CFPBs. I guess I do, in my heart of hearts, believe that there is a place for consumer protection. It does serve a societal need, and there's a place for it. I'd like to, since you have far more exposure, thankfully, than I do to the litigation process in these areas, what changes could be made to make to the actual system to achieve the end result of protecting consumers without frivolous, burdensome lawsuits that really, at the end of the day, often don't help the consumer all that much? Tell us, do you have any ideas, or how could the process be improved?
I have a broad conceptual thought without a great answer or fix, and I also one that's more specific, that with at least a theory of a fix. So the broad one is what you were alluding to. Many of these statutes are set up so that private lawyers in private practice can act as private attorneys general, meaning the attorney general of, say, Minnesota could go out and enforce consumer protection statutes on behalf of the people of Minnesota. Say, hey, act in line because you're a regulated entity. But Congress, in their wisdom, many years ago by now, said, no, we'd rather incentivize private lawyers by giving them attorney's fees under these statutes. So they should take these cases on, which the whole point of this, by the way, was the damages amounts are going to be relatively small, meaning that the claims really aren't going to be a big deal. But we should give lawyers a reason to say yes when someone comes in with one of these claims, because there's something in it for the lawyer. And I guess in some theoretical world that works out well, but it opens up a lot of perverse incentives, I think, for what cases get taken and how they're prosecuted, and whose interests are we really talking about, as you pointed out. So I don't like that as an approach in general. Though you said earlier, the devil you know, I'm not exactly saying that gosh, what I really wish is that the federal government would just take over all enforcement of all of this. I'm not sure that is a great approach either. And I'm with you. I want to be very clear. Consumer protection is important. It's kind of like what you would tell a jury if you were going to defend like a fair debt case. Is like, we should be able to agree on a couple of fundamental things, I think, at least. People should be treated fairly in the credit process, and folks who take on credit obligations should repay them on the terms that they agreed to, so long as those are compliant with law. If we can start from there, the remainder of the conversation is details revolving around them. So I totally believe, and the FDCPA, I think, had that effect. But the thing is, you look at some of the sections of that statute, I mean, it eradicated a lot of bad behavior. There's a lot of very dormant sections of that statute because none of that stuff happens anymore. So anyway, that's a side note. The specific thing, here's what I think is really problematic. In our credit reporting system, the ability to lodge a dispute about something that is on your credit report is nearly unlimited. So you can just keep hammering disputes on your credit report, and just sort of with reckless abandon. And there's not a great disincentive to knock that off if it's not a meritorious dispute or it's been resolved. And I mean, there's reasons why people might be incentivized to keep hammering the same dispute, because if it's not responded to, it comes off the report. And if it's not responded to in a way that the consumer thinks is appropriate, they can sue for it. And it seems to me, I'm no longer, at one point I was, but I'm no longer the person at a company looking through and investigating those disputes. But my sense is that a lot of bandwidth gets eaten up dealing with the volume of non-meritorious disputes that then takes away from responding to actual meritorious disputes. So we could put all of our time and resources into actually addressing the ones that need it so that we can correct anything that is a problem. And so I would love to see some mechanism to throttle repeat non-meritorious disputes through the system. I think that would do a great service to the system as a whole. Everybody. I think everybody has a vested interest in fixing that.
I liked what you said about the attorney fees too. I think again, the theory behind it was great, but there you seem to have a lot of litigation. I'm hesitant to say frivolous, but litigation that really does not have the best interest of the consumer at heart.
I once said this to somebody at the CFPB during an industry conference, and I just kind of like a look back skeptical one. So maybe it's just a dumb idea. But what had occurred to me at the time is like workers' comp has its own administrative court system that is specially designed to handle all those claims. That's all it does. Those judges know those statutes top to bottom, inside and out. Efficiency is the name of the game because there's a lot of these claims. I just wonder why they don't have their own divisions, and some courts have done something like this where litigation scheduling, like might actually be Middle District of Florida, has like a track for fair credit cases where it's all designed, like you got to give them this information by this date, you got to give the other side this information, and we're doing this by this date. And so I don't know if there's an actual mechanism to make that happen, but if I just had a blank canvas to paint on, I would say, let's do that. Let's just put them in there so these can be adjudicated quickly, so that we're not dragging through a federal or even a state, just full-blown litigation over this when somebody at the end of the day is potentially going to say, oh, and hey, I have all these attorney's fees and costs over here. Like, let's not do that. There's probably a better way. Now, I'm going to quickly be out of my depth on administrative law and probably the Constitution and what we could actually do. But that's what seems to me is more specialization in how these claims are handled. And so they're put on more of their own track, I think would go a really long way. And I would think the courts would have you get some buy-in from the courts because they are overburdened. They have too many cases on their dockets. That's just true in pretty much every jurisdiction. I don't think there's any jurisdiction really begging for more cases right now. So, if there's a listener out there who says, I know exactly how to get that done up, I don't know how you monetize that, but it's a good idea.
I do like that idea. I think there's some merit there. How to make it happen. We'll have to put our heads together.
I do agree with you. I do think that I think that applies to judges broadly, that they, as you say, they're taking the facts as presented to them. And in these cases, by the way, it's often on paper. These don't go to trial all that often, primarily because of the attorney's fees that could be building up and waiting for the defendant at the end if they don't win. But so if you just look at that for a second, is like, okay, you're presented with just a cold set of briefs on what happened or not, and the implications of that. I mean, honestly, I don't know. I would never. I say this. I'm going to say this on a public broadcast, so this will probably happen someday. But I would never want to be a judge. I think it's a very difficult job.
Yes, I would agree.
I can't remember if it was one of my partners telling me this or something, that some judge expressed a sentiment along the lines of, well, you guys are, upset with me because I'm coming at you. Well, I got two of you, meaning plaintiff's lawyer and defense lawyer, coming at me all the time. I'm outnumbered here. And so, like, as a judge, no matter what, somebody's going to think you did wrong in every case, right? You're never going to get universal agreement that, like, thank you, Your Honor, that was correct. At least on a dispositive, meaning it ends the case, it decides what's going to happen kind of situation. So it's, I think we could appreciate why that's difficult. But as you say, nonetheless, as challenging as that job is, that stuff, the orders, they carry a ton of weight because those are used. They are literally used to guide folks in these regulated industries on what they ought to do. I mean, there's a voicemail message in the accounts receivable management industry that is named after a case. Like, everybody in the United States who uses it is based on a case in Minnesota that our firm defended. And it's like, that tells you everything you need to know. It's like, okay, people in these industries read the cases and they know what they're about and they use them. So
it's interesting. I'm always curious too. We talk about judges and case law. The way that the system is set up, there are a significant amount of cases that have merit or don't have merit that never reach a judge. They're settled. A case is filed, service is completed, and is settled for alleged violations of any number. What percentage? Any idea what percentage of cases, alleged FDCPA or FCR claims are filed before a hearing or a brief is filed?
Are then settled?
Settled, I'm sorry, yes.
A lot. I
Yeah.
mean, one benefit to repeat lawyers on both sides of these cases is that you've ideally established marketplace values for the different types of claims. And so sophisticated players on both sides helps. And so you can come in and they can tell you why, on the plaintiff side, why they got this type of claim and why it's worth this. Then you might have some other information that they didn't know about, weren't thinking about, or some argument, and you can kind of trade that back and forth. And you've been dealing with each other long enough that you both know that you'll fight the case if you have to. But the point is, this has this value. Let's resolve it for that value. And that's productive. I mean, that's good lawyer work on both sides of the aisle, I think. That's an example of it. Well, I was about to say the statute working, but that of course implies that the defendant did something wrong. And I'm not willing to say that that's true in some enormous percentage of these cases. I won't say what percentage at all, but I'll just say I think in any type of litigation where the lawyers can come together early and find a way to resolve it in a way that allows everybody to walk away from the dispute, and it's over, and business can keep being business, and consumer or other business can go on about their life with closure, and it's all over. That's good. I just think that's a success. Even though the parties, frankly, are often not fully thrilled with the outcome. Defendant paid money when they didn't want to, and plaintiff probably took less money than their lawyer maybe told them at the beginning, or that they thought in their head they could get. So yeah, it's so many. The actual answer to your question is many of them do. It's the cases where it's a really high demand, or the same lawyer has sued the same defendant too many times, or we have a business practice that our client thinks is lawful and has a legitimate business reason for existing. We can't settle on that because we're going to invite other lawsuits. We need to go and then test the metal in court and get that order that you're talking about that says it's okay. Those are the times when it makes sense under a fee shifting statute to actually defend. And you got to think about that right away. Because if we get, a year into the litigation, say, we never thought about this, but maybe we ought to settle. I would hope that it would be for a very good reason, that you had never contemplated whether settlement made sense a year deep into one of these, because the demand at month 12 versus what it was in month 1 or whatever going to be heavier over here.
Well, a couple things to unpack there. So for listeners who don't have the same level of exposure to the litigation process, specifically in these industries, the reason why there is such a high percentage of settlement prior to any type of court hearings is because the cost to defend is astronomical, and it is not tied specifically to the potential damages that would be owed the plaintiff. It is the fees owed to the attorney who is prosecuting or filing the litigation.
Agree. And you mentioned something though at the beginning, and part of why we often phrase to clients, every lawsuit is an expensive compliance lesson. No matter how well you did, no matter how compliant you were, there's always something to take away. And so the more you can do at the front end to make sure that you're aware, and frankly, the folks in like third party collection are like the most versed in federal law of any industry you'll ever find, because this has been going on for so long and they just have to know about it. They train you. They train you on day one as a frontline collector about what the Fair Debt Collection Practices Act is. I mean, that's what we're talking about. Okay. But yeah, I think investing in your compliance protocols, your compliance management systems, that's great because you can control sort of what you're buying and how it's being implemented. You're controlling your destiny as it's related to litigation. Because once you get in there, I had a civil procedure professor in law school who was fond of calling or describing litigation as dancing with the gorilla. And I'm not sure what that means really, but I took the point to be you're not in control. Really. You're gonna have to go through it sort of as dictated. But compliance, that's within your control. And so if I were a business owner in that kind of industry, that's where I'd be looking to say, well, let's do that. No one loves, I don't think a lot of people are going to say, you know what I'm excited about? Paying for compliance, because it's a cost center, not a revenue center. Or at least that's the way it's thought of. And you can't. You actually have to tie them together. You're actually protecting the revenue side with the compliance side. So anyway, that's about the fourth different way of me telling you.
I think about it slightly differently, and I think there are a lot of people who think about compliance the way that you do. We are delivering a service, and you can call it a product, I guess, to our clients, and I want to deliver the best possible product to the clients who we represent in the communities that they do business, and ensuring proper compliance is how I optimize my product, right? So, yes, there are some cost-saving benefits, I suppose. Well, not I suppose. There are 100%, but it is part of a promise that we're making, I think. That's the way that I look at it. The problem is you can invest in it, if you're trying to provide that level of excellence. You can invest in it significantly in time and resources, money, and it doesn't always matter,
No, but your point's well taken. I know one. I'll throw this sort of shout out to the way that you've managed some of your businesses that I think others would do well, regardless of the industry. I think that in the financial services space, no matter where you sit, if you're a vendor, you're a service provider, that's ultimately doing some work downstream of the loan itself. I think the expectation really has become you will be a knowledge center and a compliance resource for the upstream folks. And so how can you credibly say you're going to do that if you've not actually invested and actually done the work you're talking about? And you're absolutely right. It's entirely possible to play perfectly and still lose, which is frustrating. But from a marketing perspective, from a strengthening client relationships perspective, it matters there too.
I would agree. Well, we're coming close on time. Appreciate the discussion. I have just a few more questions for you here. I like to ask guests, especially those who work in practice law or have knowledge-based backgrounds. It's not something that you jump into on day one and practice at the same level that you do after a decade. Looking back, let's say 5-10 years, what advice would you give your younger self to get ahead quicker or to reach the level that you're at?
Embrace process. That's what I've found. This is for me. I'm a process oriented human being. And that is here, it's at home, it's in my hobbies. That's just how I'm wired. It's how I make sense of the world. And so maybe it's a little niche way of saying embrace who you are, because I think a lot of newer lawyers try to emulate others that they see and who they admire, but don't have the same, they're just not wired that way. Either the pounding on the table lawyer or the very sort of who am I thinking of? Atticus Finch, very, genteel kind of like, if it's you, great. If it's not, well, that doesn't work. And so for me, I'm the most effective, my team's the most effective when process points are well oiled and there's a good machine working. And I wish I had grabbed onto that a little sooner, a few years sooner.
I'm a big process guy as well. You have been growing your team at Bassford. How can you speak a little bit about? I know at the beginning of this conversation, it's kind of an area of practice that a lot of people don't set out to, not dissimilar from debt collections. I think very few as a child are like, when I grow up, this is what I want to do. How looking back at kind of how your career has progressed in this space, how is the younger generation at Bassford adapting, and what are the differences between when you were coming up in and now?
Good questions. We're fortunate to have a really strong bench here. Here's what has not changed. People who are self-driven and conscientious. And by conscientious, I mean they care about the quality of work that they do for its own sake, just because they want to do well. That's the type of person I think who has succeeded in this line of work, maybe forever, like at the highest levels. And I don't think that's different now. How that's done and how we determine who those people are, that's the real challenge. If I really just, as transparently as I can, you can be an incredibly smart, likable person, but if we don't get to kind of those fundamentals, it's hard. It's a hard gig to do and succeed at and have longevity in. So here's the nice part about growing. As you start to build some momentum and a little bit of buzz around you, people actually kind of come to you a little bit instead of you're always recruiting. And so you can use that opportunity to vet and figure out who you want. And I think we have that right now. Not only our practice group has gone from like what was like 3 dedicated people to like 10, and not fully dedicated. So maybe it's like 8.5 or something. But I mean, it got really big in the span of a year. And the quality of people and those fundamentals are kind of what's making it stick. And I sense and I'm hearing that that's the truth about all the practice groups here. So that's it. That's the entire secret right there. Print it.
I would attest to the quality of the team that you have too. I've been fortunate to interact with some of your people, and it's been a good experience. I think as an outsider, it's an observation that I work with a lot of attorneys for various businesses and different needs. I come across occasionally amazing attorneys, but I think some attorneys fail to understand that it's relationship based too. There has to be, there's duality in the fact that you're very good and knowledgeable in your space, but I can also work with you. We're on the same page, so to speak. I think that achieving your goals and getting what you need is expedited, and there's a monetary component to that too when you work with somebody who understands you as opposed to somebody who stamps a number kind of thing. You're a file. It's a big piece of it.
You're 100% correct. I'll say this, and maybe it's not for my own good, but here's the truth. I mean, there's a lot of lawyers out there, and I think within some, gradient range can do the work to an acceptable level. What I like to think about our team is that we're, high flyers, but people also tend to like working with us. It doesn't suck to be a client of Bassford, and that really it. That to me is the essence of what you say. Because really if I'm more serious about that, you have to have client trust. If you're going to actually advise a client, especially the higher the stakes, the bigger the issue. If you're going to effectively advise them, they have to trust you. If they don't trust you, what is the point of the conversation? It's meaningless. The client's flushing money away because they really don't have buy-in with you.
Yeah,
And what is your efficacy? You might have the best advice in the world, but they're not going to use it.
I would agree. So before we jump off, anything exciting happening at Bassford besides the growth of your team that you want to share?
I guess I led with it. The Sioux Falls office is really exciting for us. We've had our eye on that community, that legal space for quite a while, and we have some big plans for that and getting that developed. We now have remote lawyers, so no brick and mortar, but Indianapolis, Atlanta, and Colorado, Fort Collins, which I am well informed is south of Denver. And so we're eyeing up other strategic locations around the country. So we're never going to become a behemoth of a firm, but we'd like to have boots on the ground in the right markets so that we have a good reach. And it's pretty cool to see that come to fruition as a thing we've been saying, for a long time, and for it to now actually have happened. Well, that's fun. I think that's called self-actualization.
That's been fun to watch the journey, and it's always great to catch up with you, Patrick. How do people
Yeah, I
get in
love
hold?
it.
How do people get in touch with you?
Oh, sure. My work email, P Newman, Newman, at Bassford. That's Bass like the fish, Ford like the truck.com. Be quite happy to chat. If our practice group doesn't do it, we're a full service law firm. So if you wanted to chat with me about a need you had, and I say, that's great, but that isn't in my wheelhouse, chances are pretty good that one of my law partners does it and I can get you in the right direction.
Thanks again for joining. Hopefully we can have you on again soon.
It would be my pleasure. Thank you.
Thanks, Patrick.